People v. Estwick.
Good afternoon, and may it please the court. Martin Sawyer, appellate advocates for appellant Dwane Estwick. The exclusion of even a single juror for discriminatory reasons violates the federal and state constitutions.
Do you wish to save any time for rebuttal?
Yes, Your Honor. Thank you for reminding me. 5 minutes, please.
5, yes.
Counsel, it seems to me in this record, the court comes up with something that may well be a neutral reason, but I never see the people come up with one. Is that incorrect?
That is absolutely correct, and you're referring to the second juror here, which is KS, which asked, when the court proceeded to step 2 with KS, the prosecutor never said a word. And the court supposed a reason for the prosecutor. And
So if the prosecutor doesn't say why, how can the court assess whether it's a race-neutral reason or not?
That's exactly correct. Batson is a burden-shifting legal regime.
And it has been short-circuited, right?
Well, it's Batson, by the judge providing the reason, yes, it does short-circuit Batson, but also the prosecutor failed to sustain their burden at step 2
So
here by
what's
not
the
providing
remedy
it.
then? What's the remedy? Do we send it back for a step 2 analysis, or is it a new trial?
It's a new trial here, Your Honor, and that's because at step 2, the prosecutor did not provide a reason, did not say anything to confirm that the court's speculation was correct.
And this is unlike an instance where the defense fails to set forth prima facie violation of Batson in the first instance, that the court, if they didn't meet their initial burden, then the court could stop it there.
That's exactly right, Your Honor. And that gets to Judge Singas's question, too. At step 1, the correct remedy, when the court incorrectly determines whether a movement has met its burden, then it goes back down for the prosecutor to put the reasons on the record at step 2, and there's a whole new process. It's not a full reversal, it's a remand. Here, the judge proceeded to step 2, and then proceeded to step 3 after speculating its own reason that the prosecutor never confirmed here on this record. And this juror was a 20-year employee of the NYPD. There was nothing in the record, even if you were to accept that this reason was the real reason that the prosecutor was said, there was absolutely nothing in the record supporting this supposed bad vibe that the prosecutor got from this juror. There was nothing made, no notes made contemporaneously about her demeanor. The judge, in saying that this was the reason for this strike, also didn't say anything about her demeanor. I'd note that a genuine bigot could have a bad vibe about someone that arises from bigotry. So there's no way of distinguishing a bad vibe as being pretextual or not pretextual without some description of the juror's demeanor. And this court, when it has upheld demeanor-based strikes in the past, including in Hecker and in Malloy, has credited trial judges who have put into the record specific facts about the juror's demeanor, for example, being austere or being hostile.
Can we talk about MG for a minute?
Yeah, I'm happy to, Your Honor.
Yeah, so is it your position that the prosecutor's mistake would always render their reasoning pretextual, or is your position that they didn't make a mistake here and they were not telling the truth about that?
My position is that a mistake is not a per se reversal. On the facts of this case, where the prosecutor had just raised a cause challenge as to this supposed reason, and the judge said, no, I have taken careful notes about this, that the juror that you're trying to exclude for cause here was not one of the jurors who was problematic. And then for the prosecutor, a couple pages later in the record, to say that was my reason, and for that to be the sole reason, there's no reasonable basis.
What if the prosecution believes that the judge is mistaken? If they believe they're right and the judge is mistaken, doesn't want to harp on it because they're not going to change the judge's mind?
That's an excellent question, and here there were several instances when the judge was making the record that the prosecutor could have intervened and say, hey, you omitted juror number 1. You said jurors 4, 6, 11, 13, and 16. I saw one raise her hand. 3 different times the judges said it for the record. Not once did the prosecutor say it. After the cause challenge, there's a protocol here where if a party disagrees with the judge's observations,
So if that record
sorry.
didn't exist, and what you just gave, that example, those examples weren't not in the record, would it then be appropriate for a judge to determine that it's not pretext?
well, here there's an
When
addition.
counsel, the prosecutor appears to disagree with what the lawyer has, with what the judge has said.
Well, if there's a genuine disagreement here, and I'll remind the court that what was attributed to this juror was deeply unfavorable to the prosecutor in light of the evidence in this case, where there was no forensic evidence presented like DNA, and was a reason that this juror was not qualified. If there's a disagreement, that party is entitled to ask for that juror to come back in so that they can resolve the disagreement. The prosecutor did not do that here, and that is strong circumstantial evidence that the prosecutor did not genuinely believe that this juror had raised her hand to these questions. So I'd like to move on briefly and address something that Judge Garcia brought up in the last argument, which was this kind of difference in standards for who's supposed to say what in this process. And I think that that the case law makes clear that there is a kind of a rhyme to this reason, or reason to this rhyme. So at step 2, it's the prosecutor's or the non-moving party's obligation to put forward the reasons for a strike. And then those reasons are what are evaluated at step 3. But this court has made clear again and again that at step 3, the judge can consider all of the evidence in the record. So in Hecker, the judge looks for record support. In Payne, the judge doesn't even need to listen to argument to consider the whole record. So what happens on appeal is we are looking at the whole record, and we are looking at whether that record supports the reasons specifically given at step 2. So I think that answers the question. And I want to note for the court that this court, in its preservation doctrine, has never found that a step 3 claim is unpreserved when the trial court ruled at step 3 with respect to the juror in question that's being brought on appeal. Ordinary preservation principles suggest that when the court considers and rules upon an issue at trial, that issue is fully preserved for appeal. A litigant does not need to specifically marshal facts in a certain way for those facts to be considered on appeal. Preservation under 470.05 applies to legal claims and issues, not arguments. And I think that there is some confusion in the appellate division about that right now.
Are you speaking generally about objections or in jury selection?
Specifically in the Batson context. A Batson step 3 claim that has been considered and ruled upon by the court below is preserved on appeal for this court's consideration. And the People v. Allen, a case that the people cited in this case, there's something that's brought up in that case, which is in a pure disparate treatment claim, the record that the court is evaluating on appeal might not be able to differentiate between what is pretext and what is not pretext, because in People v. Allen, the appellate division applied the wrong standard of review and said the prosecutor failed at step 2 because they did not supply the reasons for not striking similarly situated jurors. And the court overturned that and then reached step 3. And because there was no disparate treatment argument raised below, it was impossible on appeal to tell whether at trial these jurors were excluded because of pretext or not. That was not a preservation decision. In People v. Payne, this court specifically described it as Allen representing an articulation problem, meaning the reasons weren't articulated, so the record wasn't developed enough for the defendant to meet his burden on the merits. And then in Snyder v. Louisiana, a United States Supreme Court case from 2008, the United States Supreme Court considered a disparate treatment argument on appeal that was not raised by the litigator below. And it based in large part, its decision was based on this disparate treatment, and that's because there were other facts in the record that allowed the court to differentiate why this disparate treatment might have been pretextual. And here, that brings us back to KS, the person for whom the court speculated that there was a bad vibe. And here, to the extent that this might be perceived as a disparate treatment argument, it's because there were multiple people who had similar jury service, and the prosecutor, maybe struck one, didn't strike some others. But here we have some explanation for why there was disparate treatment on jury service, which was the court's speculation that there was some sort of bad vibe about this one particular juror. And that explanation itself is highly evocative of the exact rationales that the Supreme Court cited in Batson and cited in its most recent case, Flowers v. Mississippi. The assumption that a black juror is favorable to black defendants is exactly.
I'm sorry. So then your argument now is that even if the prosecutor had said, yes, Judge, that's my reason, right, that it would still not be sufficient. It's pure pretext whether the prosecutor had articulated it or not.
So I think there are two
The
problems.
first problem is whether or not the judge is the one providing the information versus the prosecution, right?
Well, so there are two responses to that. So first of all, I think it becomes a closer question. The judge would have to look at the record, see what else is there. And second of all, I think it would be unpreserved here, but I think there would be a procedural Batson claim where by offering this reason first, the court deviated from the proper Batson procedure. And I want to say Miller L. v. Dretke, the Supreme Court laid out perfectly that it's not enough for a trial court or an appellate court to invent a reason for exercising a pretextual strike. It must rise and fall on the prosecutor. And if a court jumps in first, the prosecutor, or I guess the party exercising the peremptory strike, it applies to defense counsel as well.
It also puts us in a somewhat awkward position of having to determine whether the court's reason is pretextual.
That's true too. But as I was
Look,
saying,
the motivation behind, the animus behind this case law, of course, is to purge our criminal justice system of these kinds of bases for striking people from the jury. So the fact that, as Judge Garcia is already suggesting, that a judge themselves may be suggesting something that is inappropriate, right?
yes, the judge.
It's very difficult. I mean, if the lawyer can't do it, why can the judge? But my point, put that aside, was that your position is regardless of whether or not the judge had said it, but if the prosecutor had said, yes, that's correct, that is my reason, your position is pretext, full stop.
My position is on this record, this would be pretext in large part because the reason itself, the substance of the reason is evocative of the very reasons that the Supreme Court of the United States has
And
said
if it
would be
wasn't
no.
pretext, but the judge had mentioned it, that's then the problem, that it's the judge, not the prosecutor, correct?
Right, if the party exercising the peremptory strike knows in advance what the judge is going to find creditable, then it eliminates the whole purpose of the Batson burden shifting framework.
Seems like a
So, yeah.
win-win argument, thank you.
Sorry, I didn't catch that.
Seems like a win-win argument that you're making there,
All right, thank you, Your Honor.
if you're
Thank you.
persuasive.
Good afternoon. Danielle Fenn for the Office of Melinda Katz. May it please the court. Here, the appellate division correctly ruled the defendant failed to sustain his burden of demonstrating a Batson violation. Initially, some of defendant's current specific claims are unpreserved for this court's review. Regarding MG, defendant never claimed below that the prosecutor's reason that she raised her hand in response to a question about needing scientific evidence was factually inaccurate. Moreover, regarding the second juror, KS, defendant never claimed below that that strike was pretextual because the prosecutor didn't strike other jurors or other panelists who had prior jury service. Moreover, in this case, the ADA did not.
How can we uphold the judge's action here? The judge cannot provide the prosecutor's basis for a challenge.
But in this case, regarding the second juror, KS, the court jumped the gun and provided these reasons, but then by not saying anything, by not contradicting that or not adding anything, the prosecutor apparently adopted that reason as his own.
Why is that
really
apparent? Why is that
really an
apparent
argument
that
we
you're?
should rely on?
Yes. How can that
It's
be?
apparent because the prosecutor disputed it. He could have said, actually, Judge, no, that's not my reason.
Silence now
Or-
is adoption, is that your argument?
Yes, it is a.
Counsel, if the judge articulates the persuasive reason for holding in favor of the strike, are you saying that it's counsel, the prosecution would actually gainsay, contradict the judge on that?
If it was something that the prosecutor didn't believe was the actual reason, the prosecutor could say that, could say, Judge, or in addition, it could be, Judge, that actually isn't my reason, or additionally, I believe that I made the strike for this additional reason, but that didn't happen here.
What is the reason that we ask the prosecutor to identify the reasons? Why do we do that?
At step two, whoever the responding party is.
Yeah, sure, but
has
in this
the
case, the
and the
prosecutor.
prosecutor.
Why do we ask that, in a broader sense?
To provide race-neutral reasons,
Well,
to a
to-
facially
well-
neutral reason for the strike.
Well, to provide an explanation of what the prosecutor's reasons are, right?
Yes.
And the reason we ask that is we are trying to determine whether the prosecutor in this case, right, is acting with racial animus.
That's correct.
Is that right?
Yes.
So how does letting the judge answer that question get us into the mind of the prosecutor?
The fact that the judge gave this reason about prior jury service.
And the prosecutor never gave any reason.
That's correct. And this issue of demeanor, that it was something in her demeanor that made the court and the prosecutor both believe that she had been on a jury that had voted to acquit, by not saying anything, by not either directly contradicting that and saying that's not the reason, or adding to that, the prosecutor adopted that reason
So you're
as his
saying
own.
that step two for a prosecutor to state a reason is gone? They don't have to. As long as the judge takes care of it, it's fine.
No, at step two, the prosecutor should give, the prosecutor is supposed to give the
But
reason
here-
in this specific. I'm
Here,
sorry.
you're saying you can just, if the judge is gracious enough to give the prosecutor a reason, the prosecutor can then just adopt it, and then step two is satisfied, and then the judge is to assess the judge's own rationale.
In this specific case, the judge perhaps jumped the gun in providing these reasons. And in terms of it more
I'm
generally
not really
in
clear about what you
Batson,
mean by that. Jumped the gun. That makes it seem like the judge just needed to wait and then provide reasons.
No.
I don't think that's what you mean.
No,
Okay.
Your Honor.
I also actually think you don't mean adopted, because adopted seems to mean, oh, I'm persuaded by that reason, that sounds good, as opposed to confirming, right? I think you mean that the silence confirms that that is the prosecutor's reason.
Yes, it confirms his reason. It's not that the judge talked him into the reason, or
So are
that the
you
judge has
saying
no burden
somehow
to.
the judge is able to discern what's in the mind of the prosecutor and then satisfy step two as a result?
In this specific case, it seemed like there was something in this panelist's demeanor that was evident
A
in the
bad
courtroom.
vibe?
It seemed like it was something that she said, because the court did say the people weren't happy with the way that she said
Did the
it.
court say a bad vibe? Is that an objective basis that we should be making decisions, or we are then put in a position to be able to review it? The judge is doing it. A bad vibe.
And this-
You're saying somehow, because there were some sort of feelings, that was sufficient, that just jumped off the page? So of course that was the prosecutor's reason? Is that essentially what you're saying?
In terms of the term bad vibe, the court said a few things, but in terms of bad vibe, that implies some demeanor-based reason. And the court did say that the
Don't you
people were not.
admit that it would, at least, if the prosecutor, him or herself says it, it would then put us in the proper sequential order of review, rather than the judge inserting what the judge thinks the prosecutor is basing a concern off of?
In this specific instance, generally, it is a burden-shifting regime or burden.
But counsel, put it
But
another way,
here-
to go back to what Chief Judge's point was earlier, the purpose of the process and the sequencing is because we want to know if the prosecutor has a valid reason. So it seems to defeat that purpose for a judge perhaps to come up with a good reason the judge may have not liked to seat that juror, and then provide that and assume, I'm not saying this is the case, but assume there is a prosecutor or a defense lawyer who really wants to strike that juror for an inappropriate reason and does not have a race-neutral reason. In fact, it's a bad peremptory. Now has this lifeline, and they can just say, sure, yeah, that's right. Why suggest a reason to a party that will get them out of having to justify the strike?
I don't think in this case, it seemed like.
Why is this case different than any case? I mean, we don't know what happened here. We don't know on this record what the prosecutor would have said.
The fact that the prosecutor didn't say anything, didn't add or contradict to what the court said, he did confirm that those were his reasons.
No, he
And it
didn't.
seems
There
like-
was no
Confirmed
confirmation.
it?
I mean, we're talking about a burden that the people have, right? And if it was the other way around, if we were talking about a burden that the defense had, and if a judge had filled in the blank, I think you would be arguing the defense didn't meet their burden. I mean, you're in a sort of untenable position, but I don't see how you can say a burden has been fulfilled when the people stood mute.
It's the fact that the prosecutor didn't add or
Okay,
dispute the
so are
reasoning.
you saying because the prosecutor didn't add or anything that there is some sort of adoption? Are you saying going forward, the rule should be that as long as a reason is put on the record at step 2, albeit by the judge, that that's okay? And you want us to clearly say, going forward, the prosecutor doesn't have to do it, the judge can satisfy it for him?
In this case, and in Batson generally, there is this burden shifting of the people or the non-movement providing reasons and then the determination of pretext. In this specific case, the court provided those reasons and the prosecutor either adopted, did not challenge them,
But
confirm
again,
them.
yes or no? Going forward, is step 2 satisfied as long as the trial judge sets forth a reason and the prosecutor acquiesces, and then by that acquiescence adopts it? It's okay.
I don't think it's okay, Batson's
It's
clear, this
satisfied.
court-
Step 2 is satisfied if the sequence happens that way. That is essentially what you are saying.
Yes, in this specific case with this, where it seems like it was apparent to the parties that that there was something in this particular juror's demeanor and the way that she said it, because the court even says this is usually.
I think the point is, it doesn't matter if it's apparent to the judge. What matters is that the prosecutor has got to articulate their reason. You can't just not say anything and have a person who's supposed to be the neutral, right, the neutral person in the courtroom start articulating reasons in support of a peremptory.
Yes, Your Honor. In this case, it's not that, in any case, the judge has to provide
Let me
reasons.
ask you
That's
this.
not the
Have
case
you,
at all.
have you, in your practice, have you seen this before? I mean, I couldn't
Honestly-
find a case where I'd ever seen this before.
No, I've never seen the specific factual for this
You keep
scenario
answering
where.
about in this
the
case,
court-
but the problem I have, I think, is really a much broader one. And imagine it this way. My sixth grader goes in for a social studies test. I'd like to know that she knows the answer to the questions. But instead of filling the answers, the principal comes in and says, here's what the answers are, and then my sixth grader leaves. I have no confidence that she knows anything about the contents of that test, but that's what I'm trying to find out.
In fairness, I think it would be, these are the answers I think you would give.
Yeah.
I think in this case, I think there's a few things. The
But this
fact
is
that the-
every case, right? This is back to Judge Troutman's question. You're effectively asking for a rule and look, we could save a lot of time in trials. We could get more cases through the system if we just let the judge decide these without asking the prosecutor.
No, I don't think that it's a matter, in terms of Batson, it's the proponent and then the responding party. It's not ever the judge giving reasons or that the judge is giving the answers to one party or the other party, but in this specific case, it seemed apparent to both the court and the prosecutor that they both believed that this particular panelist is something
Counsel,
in
you keep
the way
saying
that
that they
she said
both
it.
believed, and obviously that's the problem I think we're having here. I mean, the burden Batson seems very reasonable in terms of showing that the strike isn't racially motivated and it isn't pretextual, and we asked the prosecutor to do that. And is it really that great of a burden even in this case? And I'm not saying it would be enough, but if the prosecutor just said, yes, that was my reason, is that asking too much here?
I don't think it's asking too much. I think when the court said that it's, that something in her demeanor, that the way that she said it, that the court said, it made the ADA nervous, that if she had voted to quit, the ADA would be nervous, and that would be a legitimate reason. It's that the ADA, by not adding something, it's not that no one has to provide, as the non-moving party, no one has to provide reasons.
Counsel, at the risk of saying something I think you've heard 4 or 5 times, the purpose of the Batson process is to ferret out this kind of invidious discrimination bias that can sometimes take place. Are you saying that it's possible, and the mechanism by which that is done is to extract answers from the person who's been accused of using bias so that they can be evaluated? It's not really like what the reason is, it's to look behind it and try to understand what the real motivations are. I don't understand how you can argue that that can be done if you're not getting the words from the person who's been accused of engaging in this bias.
In this specific case, I do understand this. The burden at step 2 is to provide reasons.
But it's not really,
fine.
it's, yes, that's what you have to give the reasons, but the purpose of giving the reasons is to give the court the ability to evaluate the genuineness and credibility of those reasons as opposed to some other pretextual pretextual purpose.
Yes, Your Honor. And in this specific case where the fact that the ADA didn't challenge what the judge said and didn't add to anything the judge said and said there's additional reasons, really points to the fact that those were the ADA's reasons. And in this case, there must have been something
Counsel,
in her
even if they
demeanor.
were,
I'm sorry?
let's assume you're right, it may be in his head. The problem is subjective inquiry. There has to be a subject, and the subject is the DA, it's not the judge, right? I mean, you'd agree with that, wouldn't you?
Yes.
So how can you determine the subjective mindset unless you're a mind reader?
In terms of the reasons, this reason about prior jury service and the belief that there was an acquittal, the fact that the judge said it and not the ADA doesn't mean the judge can't then determine whether that reason is pretextual, because it must have been something in her demeanor, because the defense attorney also doesn't say anything about her demeanor. It says, we don't know what the verdict is. And it was apparent to the court, as apparently apparent to the ADA, it was something, like the judge said, in the way that she said it, apparently the tone of her voice, it might have been her facial expression, that indicated that she had voted for an acquittal in a prior instance of jury service, and that would be a race-neutral reason. My light is on. If there are no further questions, I'll rely on my chief.
Thank you. Your Honors, as several of you noted in that last argument, step 2 squarely places the burden on the party exercising the peremptory strike to come forward with a race-neutral reason. An adoption of a standard that would allow a prosecutor to remain silent at step 2 would be a radical deviation from the Batson protocol. It would make it impossible to evaluate claims at step 3 and make it impossible to evaluate claims on appeal. I just want to address one thing my colleague said here. She said that that both parties believed that there was this bad vibe, and I want to make clear that the record shows that the defense counsel contested this and said that that was not borne out, that he didn't get that vibe, that he didn't understand why this juror had been struck given her history with the NYPD. I also want to note that sometimes.
The same question I asked. Have you ever seen this before?
No, Your Honor.
Thank you.
So I want to point out that sometimes, one of the reasons that the Batson protocol is difficult is because sometimes reasons can show up as true that are in fact pretext. And it's really important, Batson's a difficult process because you're evaluating whether somebody who's in front of the court constantly is telling the truth or not. And these are repeat players in the court system. And for that reason, it's really important to actually get these reasons on the record rather than the judge relying on his or her own intuition and then evaluating the judge's own guess as to what the reason is. So I just want to conclude with, I want to note that the people right now are asking to impose a kind of new Batson rule with respect to KS. As former Chief Judge DeFiore in the Judicial Task Force report last year recognized, protecting the rights of jurors and defendants from discrimination requires strengthening Batson, not weakening it. At a moment in history when other states, including our neighbors New Jersey and Connecticut, are taking steps to enable trial courts to better protect against invidious discrimination and appellate courts to better evaluate when trial courts deviate from that requirement, this court should decline the invitation to move our state in the opposite direction. So, thank you.
Thank you.